So, hello everyone and welcome to Wise IAS, your true companion in UPSC preparations. In the last lecture, we have started part 3 of Indian Constitution and that was about the fundamental rights. Continuing in this series, today we are going to start with Article 17 and covering up the next few articles. I hope all of you are clear up to Article 16. So, before we start, I just want you all to be ready with your basic toolkit, that is your Bill Act of Indian Constitution, highlighter, pen, copy. So, now starting with Article 17. Article 17 just talks about untouchability. Article 17 talks about untouchability. The word untouchability is nowhere defined in the Indian Constitution. Secondly, if you can notice, this word is in inverted commas. So, the word is not defined and there is पूरा का पूरा article in the Indian Constitution about this word. Firstly, let us know what does the word untouchability mean. The word untouchability, rather nowhere it is defined in the Indian Constitution, but the version of Supreme Court on this word is we just don't have to go into the grammatical meaning of the word untouchability. The Supreme Court said. The Supreme Court said we just don't have to go into the grammatical meaning of the word untouchability. The article was given apart in the Constitution because of some reason, and we just have to go back into the history and know what the reason was. At that time, untouchability was a major problem. It was a big problem even in the time of British India. So the framers of the Constitution kept in mind to eradicate this problem. In order to eradicate the problem of untouchability, they have given a place to abolish untouchability in entire Article 17. So at that time, what the practices were in relation to untouchability, we just have to go into this meaning. Untouchability, it could be a discrimination with any person on the basis of caste or on the basis of color or anyhow. हिंदी में बोले तो किसी को अछूत कहना या मानना अनटचेबिलिटी में कवर्ड होगा. Article 17 says abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. Firstly, they are forbidding untouchability, and secondly, they are going to make untouchability a punishable offense. So अगर हम अनटचेबिलिटी को फॉरबिड कर देंगे, अनटचेबिलिटी प्रैक्टिस ही नहीं होगी। अगर अनटचेबिलिटी प्रैक्टिस ही नहीं होगी, फिर भी ऐसा तो हो सकता है ना कि कुछ लोग अनटचेबिलिटी को प्रैक्टिस करें। तो अगर वो लोग अनटचेबिलिटी को फॉरबिड होने के बाद भी प्रैक्टिस करेंगे तो उनको क्या पनिश किया जाएगा, राइट? तो दैट वाज द विजन ऑफ द फ्रेमर्स ऑफ आवर कॉन्स्टिट्यूशन। The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law, right? तो अनटचेबिलिटी को एक ऑफेंस बना दिया, दैट इज पनिशेबल बाय लॉ। नेक्स्ट इज योर आर्टिकल 18। आर्टिकल 18 टॉक्स अबाउट अबॉलिशन ऑफ टाइटल्स। अबॉलिशन ऑफ टाइटल्स, अब टाइटल्स हमें कौन से अबॉलिश करने हैं? ब्रिटिश रूल के टाइम पे ही इंडिया में टाइटल्स का बड़ा बोलबाला था। राजा, महाराजा, महाराज, राइट? तो ऐसे कुछ टाइटल्स थे जो एक व्यक्ति विशेष के नाम के आगे लगाए जाते थे, उसके नाम का प्रीफिक्स हो जाता था वो टाइटल। तो आर्टिकल 18 कहता है कि ये सारे टाइटल्स को अबॉलिश कर दिया जाएगा। आर्टिकल 18 रीड्स एज क्लॉज 1, नो टाइटल नॉट बीइंग अ मिलिट्री और एकेडमिक distinction shall be conferred by the state. So in the very first clause of this article, there is a responsibility of the state, that the state shall not give any title to any person, except there are two exceptions. The titles could be academic or for military purpose. The state can give only two type of titles, that is academic and military. No other title can be given by the state, right? Clause 2, no citizen of India shall accept any title from any foreign state. So the sub clause 2 or clause 2 of article 18 is imposing a responsibility on the citizens, that a citizen of India will not accept any title from any foreign state. The very next clause 3 is imposing a restriction on the non-citizens. Now, how we can impose restrictions on the non-citizens? When the non-citizens are in relation to the Indian state. So let us see how. Article 18 and clause 3 reads as, no person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the state or accept without the consent of the president any title from any foreign state. So without the consent of president, the word president is here. Without the consent of president, any non-citizen who is holding any office of profit under the state of India or under the trust for the state of India, he cannot accept any title from any foreign state without the consent of president. The very next clause talks about any person. Any person. So let us read how. No person holding any office of profit or trust under the state shall, without the consent of the president, accept any present, emolument, or office of any kind from or under any foreign state. So, any person who is having office of profit or trust under the state of India cannot accept any gift or any emolument from any foreign state. I think all of you are clear on this. Let's move ahead. The next part or the next portion of part 3 is talking about right to freedom. Starting with Article 19, which guarantees some of the freedoms. Protection of certain rights regarding freedom of speech, etc. All citizens shall have the right to freedom of speech and expression. So under 19, Article 19, the very first words, they are all the citizens. Available to all the citizens. So it's clear that these freedoms which we are going to discuss here are only for the citizens of India and no one else. First, the very A, to freedom of speech and expression. Every person is having a right to freedom of speech and expression. You can express your feelings. So, a very famous case that decriminalized homosexuality was based on the freedom of expression, right? So every citizen is having freedom of speech and expression. You can speak anything you want, you can express anything you like. B, to assemble peacefully and without arms. So citizens of India can assemble anywhere peacefully and without arms. कहीं भी एकत्रित हो जाएंगे हथियारों के बिना. To form associations or unions or cooperative societies. So the citizens of India can form trade unions, they can form auto unions, they can form any of the union or associations or cooperative societies to move freely throughout the territory of India. So the citizens of India can move from this part of India to this part and from this part to this part anywhere in the India. They can move freely. There can be no restriction. I'll be talking about the restrictions, but अभी के लिए आप इस चीज को समझिए. Every citizen has a right to move in any part of India and he can move freely. No restrictions are there. To reside and settle in any part of the territory of India. So the citizens of India, they can reside in any part of India. There is no restriction. To practice any profession or to carry on any occupation, trade or business. किसी भी तरीके का व्यापार या प्रोफेशन आप कीजिए. The state cannot interfere. Now, the main part. Clause 2. Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law in so far as such law imposes reasonable restrictions on the exercise of right conferred by the said subclause in the interest of sovereignty, integrity of India. in the interest of sovereignty and integrity of India, reasonable restrictions can be imposed, or the state can make any law. Nothing can restrict the state from making any law in the interest of sovereignty or integrity of India that abrogates, that takes away the freedom given to you under clause E. Right? The society of the state, friendly relations with foreign states, public order, decency or morality, and some more things are given here. So in the interest, प्यार से आप इसको सिप बुला सकते हैं, फेमस सॉवरेनिटी, इंटीग्रिटी एंड पब्लिक ऑर्डर के इंटरेस्ट में आपकी राइट्स, फ्रीडम्स जो हैं वो ले ली जा सकती है. द स्टेट कैन मेक एनी लॉ. Contempt of court, defamation or incitement to an offence. Nothing in subclause B of the said clause shall affect the operation of any existing law in so far as it imposes or prevent the state from making any law imposing in the interest of sovereignty, integrity of India or public order, reasonable restrictions on the exercise of the right conferred by the said sub clause. अगेन सिप के लिए सब क्लॉज बी में जो फ्रीडम दी है उसको लिया जा सकता है. नथिंग इन द सब क्लॉज सी ऑफ द सेड क्लॉज shall affect the operation of any existing law. अब there is a word any existing law. यानी कि कॉन्स्टिट्यूशन के आने से पहले के कोई लॉ, अगर वो ये फ्रीडम को कर्टेल करते हैं इन द इंटरेस्ट ऑफ सिप, sovereignty, integrity and public order, they are valid. Right? Next, clause 5. Nothing in subclauses D and E of the said clause shall affect the operation of any existing law in so far as it imposes or prevent the state from making any law imposing reasonable restrictions on the exercise of the rights conferred by the said subclause, either in the interest of the general public or for the protection of the interest of any scheduled tribe. So here are the words written for the interest of general public and scheduled tribes. This subclause D and E were talking about your freedom to move freely in any part of India and to reside in any part of India. Some reasonable restrictions can be imposed. You can see if you are going to East India, the eastern part of India, the government can restrict your movement in the interest of general public residing in that area or for the tribal areas, tribal people. You have to take permission from the government to move in some parts. Clause 6. Nothing in subclause G of the said clause shall affect the operation of any existing law in so far as it imposes or prevent the state from making any law imposing in the interest of general public reasonable restrictions on the exercise of right conferred by the said subclause, and in particular, nothing in this said subclause shall affect the operation of any existing law in so far as it relates to or prevent the state from making any law relating to. Everything is same and 2 points are given here. The professional or technical qualification necessary for practicing any profession or carrying on any occupation, trade or business. So when you are carrying on any trade or occupation or business, the government can impose some restrictions, and these restrictions should be reasonable one. So how the government can impose reasonable restrictions? If you are doing LLB, only then you can practice as an advocate, and only then you can go for judiciary exams. And if you are opting for medical science, only then you can become a doctor. It's not like you are opting for medical science and you are practicing law. You want to practice advocacy in the courts. So government can impose reasonable restrictions for business, trade or profession. Right? The government can list down the professional or technical qualifications for a particular profession or business. The second point. Now, before going with the second point, let's just imagine a situation that if the government could not impose these reasonable restrictions. If the government could not impose these reasonable restrictions, and the power of this freedom to practice and profession, this freedom of business, trade and profession is unlimited. So everyone would be opting for the profession that has much income. गली गली में हमें क्लिनिक्स खुले दिखेंगे जो कि अनप्रोफेशनल या अनक्वालिफाइड डॉक्टर्स होंगे. हमें जगह जगह पे लॉयर्स के ऑफिस दिखेंगे जिनको लॉ के बारे में कुछ पता ही नहीं. दिस इज व्हाई गवर्नमेंट कैन इम्पोज restrictions or can specify the technical qualifications required for the practicing of some professions, business or trades. Point number 2. The carrying on by the state or by the corporation owned or controlled by the states of any trade, business, industry or service, whether to the exclusion, complete or partial of citizens or otherwise. Now, Indian Railway could be the best example for this point. The government can reserve some of the trades, businesses or professions that are solely to be managed by the government, that are solely to be taken care of by the government. Government can, in short, monopolize the profession, trade or business. Article 20. Article 20 talks about protection in respect of conviction for offences. Article 20 you can say is the backbone of criminal law. Under Article 20 काफी बार देखा जाता है कि सुप्रीम कोर्ट में ये चर्चा का विषय बना होता है. So, what is Article 20? Article 20 talks about protection in respect of conviction for offences. Clause 1 talks about no person shall be convicted of any offence except for violation of law enforced in the time of commission of that the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law enforced at the time of commission of an offence. तो बेसिकली मान लीजिए एक ऑफेंडर है जिसने कोई ऑफेंस किया. He is accused of murder. A is accused of murder. So while the trial of A in the court, A is found guilty. ये प्रूव हो गया कि A ने मर्डर किया है. A is the murderer. So the judge, while pronouncing the judgment or the sentence, he cannot inflict the punishment more than that which is provided for murder in the law, that is your IPC. Whatsoever is the punishment in IPC, the judge cannot inflict more punishment than that. The very first thing. The second thing in this article is the judge has to see if A is guilty of murder, he cannot be guilty of culpable homicide at the same time. He can be sentenced for one offense. If there is a confusion that A might have committed culpable homicide or A might have committed murder, there is no provision, there is nothing that says कि A को मर्डर की सजा भी दे दो और कल्पेबल होमिसाइड की भी दे दो. या तो उसको मर्डर की सजा देंगे या कल्पेबल होमिसाइड की सजा देंगे. There is a difference in murder and culpable homicide, right? तो the gist of clause 1 ये कहता है कि एक इंसान को आप उतनी सजा देंगे जितनी उस ऑफेंस में लिखी गई है, उससे ज्यादा नहीं देंगे. दूसरी बात, उसको एक ही टाइम पे दो ऑफेंस की सजा नहीं दे देंगे. अगर मान लीजिए दोनों ऑफेंस बनते हैं, कल्पेबल होमिसाइड भी हो सकता है, मर्डर भी हो सकता है, दोनों में से किसी एक की सजा मिलेगी, राइट? And third thing, very important part in this section. अब मान लीजिए ए ने मर्डर किया 1 जनवरी 1991 को. ट्रायल चला 1 जनवरी 2000 तक ट्रायल चला. इन बिटवीन 1998 में हमारा आईपीसी जो है वो अमेंड हो गया और मर्डर की सजा मान लीजिए उसमें कर दी गई 10 साल, जो कि पहले थी 3 साल. हाइपोथेटिकल एग्जांपल, जस्ट इमेजिन 1991 के टाइम पे जब ऑफेंस हुआ, मर्डर की सजा थी 3 इयर्स एंड 2000 में जब ट्रायल कंक्लूड हुआ, ए वाज फाउंड गिल्टी ऑफ मर्डर. इन बिटवीन 1998 में उस 3 साल की सजा को 10 साल बढ़ा दिया गया. तो व्हाइल प्रोनाउंसिंग द जजमेंट, द जज कैन नॉट सेंटेंस ए फॉर 10 years. द पनिशमेंट फॉर मर्डर इन 1991 was 3 years. So the punishment at the time of commission of offense is the only one that could be sentenced. राइट? तो दो तरीके की अमेंडमेंट्स की जाती हैं. एक होती है प्रोस्पेक्टिव, एक होती है रेट्रोस्पेक्टिव. रेट्रोस्पेक्टिव वो वाली अमेंडमेंट होती है जो समय में पीछे से जाते हैं. अब मान लीजिए 1998 में अमेंडमेंट करी और इसमें बोला गया कि 1991 से जो भी मर्डर हुए हैं उन सबकी सजा जो होगी वो 10 साल होगी. इसको कहेंगे रेट्रोस्पेक्टिव. प्रोस्पेक्टिव वो होगी 1998 के बाद जो मर्डर होंगे, जब अमेंडमेंट आई उसके बाद जो मर्डर होंगे उसकी सजा 10 साल. क्लॉज 2, नो पर्सन शैल बी प्रोसिक्यूटेड and punished for the same offense more than once. So basically it is talking about double jeopardy. No person can be sentenced or tried for an offense twice. एक ऑफेंस के लिए किसी पर्सन को 2 बार कोर्ट में पेश नहीं किया जाएगा. यानी कि अगर ए ने मर्डर किया था, उसको मर्डर की सजा दे दी, अब उसके ऊपर ट्रायल दोबारा से चला दो कि देखते हैं कल्पेबल होमिसाइड भी बन रहा था, उसके बाद उसको कल्पेबल होमिसाइड की सजा दे दी। तो एक ऑफेंस या तो मर्डर हो सकता है या कल्पेबल होमिसाइड हो सकता है, उस ऑफेंस के लिए उस पर्सन के ऊपर 2 बार केस नहीं चलाया जाएगा, राइट? The next is, no person accused of any offense shall be compelled to be a witness against himself. So a person cannot be compelled to be a witness against himself. A person cannot be compelled to be a witness against himself. किसी भी व्यक्ति को कंपेल नहीं किया जा सकता कि वो अपने खिलाफ गवाही दे, एंड स्पेसिफिकली जब वो गवाही उसके खिलाफ ही यूज की जाएगी। किसी भी इंसान को ये कंपेल नहीं किया जा सकता। अब मान लीजिए ए के केस में ए को कंपेल नहीं किया जा सकता तो वी गिव अ स्टेटमेंट टू द पुलिस। Statement to police or any other judicial authority or any authority, so that the statement given by A could be used as evidence against A in prosecution. So a person cannot be compelled to be a witness against himself, right? Next is your Article 21. बहुत छोटा सा आर्टिकल और सबसे बड़ा स्कोप रखने वाला ये आर्टिकल है। आर्टिकल 21 की अगर बात करें तो देयर आर न्यूमरस इंटरप्रिटेशंस। इंप्लाइडली ये अपने अंदर बहुत कुछ समेट कर बैठा है। इस आर्टिकल में प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी, no person shall be deprived of his life or personal liberty except according to the procedure established by law. अब लाइफ एंड लिबर्टी को सुप्रीम कोर्ट ने अपने बहुत सारे ऑर्डर्स में जो है एक्सप्लेन करा कि व्हाट इज लाइफ एंड लिबर्टी अंडर आर्टिकल 21 मींस। No person can be deprived of his right to life and liberty. किसी भी इंसान से उसकी जिंदगी नहीं छीनी जा सकती, right? Article 21A is your right to education. The state shall provide free and compulsory education to all the children of the age of 6 to 14 years in such a manner as the state may by law determine. So under Article 21A, the age given is 6 to under Article 21A, the age given is 6 to 14 years. It is the duty of state to make certain laws ensuring the right to education for the children between the age of 6 to 14 years. The number here 6 to 14 is very much important. We will be talking about this in DPSP, Directive Principle of the State Policy again, and we will see what is the difference here and what is the difference here. There is a provision in DPSP also about imparting compulsory education. It is the duty of state, right? Next is your Article 22, protection against arrest and detention in certain cases. So in Article 2 there is protection given in certain cases. Let's begin with protection against arrest and detention in certain cases. No person who is arrested shall be detained in custody without being informed. बिना कारण बताए उसको डिटेन नहीं किया जा सकता, उसको कस्टडी में नहीं रखा जा सकता, as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. यानी कि किसी भी व्यक्ति को डिटेन करके प्रिजन में या कहीं भी नहीं रखा जा सकता। एक व्यक्ति है जिसको पुलिस वाले आए और पकड़ कर ले गए। अब उसको नहीं बताया गया कि उसको कहां लेके जाया जा रहा है और क्यों लेके जाया जा रहा है। इट इज वायलेशन ऑफ आर्टिकल 22 क्लॉज 1। Now, the second part of the clause 1, the same clause is talking about A is having right to consult his legal practitioner of his choice, right? वो अपनी मर्जी का वकील कर सकता है, उससे बात कर सकता है। Clause 2, every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in the custody beyond the said period without the authority of a magistrate. अब पहली बात तो ए को अरेस्ट नहीं कर सकते बिना कारण के या उसको बिना कारण बताए, उसको कारण बताना पड़ेगा। द रीजन ऑफ अरेस्ट इज हैविंग राइट टू लीगल प्रैक्टिशनर ऑफ हिज चॉइस। नाउ विदिन 24 hours he is to be taken to nearest magistrate, the court of magistrate. He is to be produced before a court of magistrate within 24 hours, and this time is excluding the time of journey. Now, अब ए को अरेस्ट किया, उसको कारण बता दिया, ए ने अपना लीगल प्रैक्टिशनर से बात करनी चाहिए तो वो भी हो गई। 24 घंटे के भीतर उसे मजिस्ट्रेट के पास ले गए। अब क्या होगा? मजिस्ट्रेट बताएगा क्या उसका डिटेंशन ठीक है या नहीं है। अगर तो डिटेंशन ठीक है, अगर उसको अरेस्ट करने का कोई कारण था तो उसको अरेस्ट करके कस्टडी में रखा जाएगा। अब कस्टडी या तो पुलिस कस्टडी होगी या जुडिशियल कस्टडी होगी। फॉर यूपीएससी यू नीड नॉट टू नो मच अबाउट दिस। सो बेसिकली द मैजिस्ट्रेट हैज टू ऑथराइज द डिटेंशन कि फर्दर डिटेंशन होगा या नहीं होगा। दिस इज द रोल ऑफ मैजिस्ट्रेट, एंड द पुलिस ऑफिसर्स who are arresting A, they are to bring the arrested person before a magistrate within 24 hours. This time is very much important. Why? अगर ये टाइम नहीं बताया जाएगा, ये टाइम नहीं होगा यहाँ पे, तो किसी एक व्यक्ति को बिना कारण के तो बहुत देर तक डिटेंशन में रखा जा सकता है, हरासमेंट करी जा सकती है। इसलिए यहाँ पर 24 घंटे का टाइम दिया। Clause 3, nothing in clause 1 and 2 shall apply. अब clause 1 और 2 में कुछ अप्लाई नहीं होगा to any person who for the time being is an enemy alien. बाहर से आया हुआ कोई दुश्मन है, उसके ऊपर clause 1 और 2 अप्लाई नहीं होगा। When any person who is arrested or detained under any law providing for preventive detention. अब प्रिवेंटिव डिटेंशन एक्ट के अंदर अगर उसको अरेस्ट किया है तब भी ये आर्टिकल जो है ये प्रोविजन क्लॉज 1 और 2 की अप्लाई नहीं होगी। नो लॉ प्रोवाइडिंग फॉर द प्रिवेंटिव डिटेंशन शैल ऑथराइज द डिटेंशन ऑफ अ पर्सन फॉर अ लॉन्गर पीरियड देन 3 months। अब प्रिवेंटिव डिटेंशन एक्ट भी जो है, कोई भी ऐसा अगर लॉ बनेगा तो वो 3 महीने से ज्यादा किसी भी इंसान को अरेस्ट करने के लिए अथॉरिटी नहीं दे सकती। An advisory board consisting of persons who are or have been or are qualified to be appointed as the judges of the High Court has reported before the expiration of said period of 3 months that there is in its opinion sufficient cause for such detention. अब प्रिवेंटिव डिटेंशन में एक कमेटी बिठाई जाएगी हाई कोर्ट के जजेस, वो लोग जो या तो हैं या रिटायर हुए या बनने के लायक हैं। जब तक वो नहीं बताते कि 3 महीने से ज्यादा उस आदमी को या उस इंसान को डिटेन किया जाना चाहिए, तब तक प्रिवेंटिव डिटेंशन 3 महीने तक की रहेगी, उससे बढ़ नहीं सकती। बढ़ तब सकती है जब ये कमेटी अपॉइंटेड जो हाई कोर्ट जजेस, they are qualified to be high court judges or they are retired or they are high court judges, एक बोर्ड बना दिया जाएगा, इसको एडवाइजरी बोर्ड का नाम दिया जाएगा, राइट। Provided that nothing in this sub clause shall authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament under sub clause B of clause 7, or such person is detained in accordance with the provision of any law made by Parliament under sub clause A and B of clause 7. Now, clause 5. When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall as soon as may be communicate to such person the grounds of which the order has been made and shall afford him the earliest opportunity of making a representation against the order. जितना जल्दी हो सके उस इंसान को बताया जाएगा कि तुम्हें प्रिवेंटिव डिटेंशन में क्यों रखा गया, और वो उस ऑर्डर के लिए अपनी बात का रिप्रेजेंटेशन रख पाए। Clause 6. Nothing in the clause 5 shall require the authority making any order as is referred to that clause to disclose facts which such authority considers to be against the public interest to disclose. अब it is not binding upon the authority to disclose the facts that why that person is kept in preventive detention. Clause 7. Parliament may by law prescribe, अब क्या prescribe करेंगे, the circumstances under which and the class or classes of cases in which a person may be detained. कब और किन किन लोगों को कैसे कैसे प्रिवेंटिव डिटेंशन में रखा जाएगा, फॉर अ पीरियड लॉन्गर देन 3 मंथ, 3 महीने से ज्यादा, under any law providing for the preventive detention without obtaining the opinion of advisory board in accordance with the provisions of sub clause A of clause 4. एडवाइजरी बोर्ड की रिकमेंडेशंस के बिना 3 महीने से ज्यादा कब तक एक इंसान को प्रिवेंटिव डिटेंशन में रखा जाएगा, पार्लियामेंट ये लॉ बना सकती है। The maximum period for which any person may in any class or classes of cases be detained under any law providing for preventive detention, और पार्लियामेंट बता सकती है कि मैक्सिमम पीरियड क्या रहेगा इन लोगों को प्रिवेंटिव डिटेंशन में रखने का। The procedure to be followed by the advisory board in an inquiry under sub clause A of clause 4, और जब एडवाइजरी बोर्ड जो हमने बनाया था वो क्या प्रोसीजर फॉलो करेगी। तो दिस इज ऑल फॉर टुडे। इन द नेक्स्ट वीडियो हम डिस्कस करेंगे राइट अगेंस्ट एक्सप्लॉयटेशन और उसके आगे का पार्ट। आई होप आज हमने जो कुछ भी किया, you are clear on each and every topic, you are conceptually clear about everything. This is all for today. Thank you. Have a nice day.